Welcome back, sir. Let us revise the Partnership Act. Weightage of 20 marks. Weightage of? So, what is the weightage of the Indian Contract Act? Contract Act will be 32 marks. Hoga 21 marks. That is 7 plus 7 plus 7. Right? So, and when it comes to weightage of partnership, its weightage will be 20 marks. How many marks? So, you have three questions from this chapter 1C, 3A, 5B. So, 6 marks, 7 marks, and 7 marks, 7 plus 7, 14, 14 plus 6, 20. So this will be the pattern. You will be getting 20 marks from Partnership Act. History. What is the history of the Partnership Act? Once upon a time, Partnership Act is part and parcel of the Indian Contract Act. Provisions relating to contract of partnership repealed, and they formed a new act called the Indian Partnership Act. Yes or no, sir? This was happened. This was happened on the 8th April 1832. This was governed by the Registry of Farms and MCA, Ministry of Corporate Affairs. Partnership Act is regulated by the Ministry of Corporate Affairs and ROF, Registry of Farms. Applicability of the Act. The Act is applicable to whole of India. Applicable to when it comes to applicability, the Act is applicable to whole of India, including Jammu and Kashmir. The Act is applicable from 1st October 1932. However, Section 69 came into force from 1st October 1933. This Act is applicable only to partnerships, but not applicable to LLPs, but not applicable to companies. This Act applicable only to partnerships, but not to LLPs, but not to companies. So, whenever the provisions of the Partnership Act is silent, the provisions of the Contract Act will be applicable. For example, Partnership Act says to enter into contract of partnership, there must be buyer and seller. How they are supposed to be in Partnership Act is silent. Contract Act says that the partners must be major, soundman, not disqualified by law. So, Partnership Act says to enter into contract of partnership, there must be business. Which kind of business? Act is silent. The business must be lawful, legal, but not unlawful. Who said that? Contract Act. So whenever the Partnership Act is silent, we will apply the Indian Contract Act. Next, this one is very important from exam point of view. Definition of the contract of the partnership and its essentials. So important from exam point of view. Star, superstar, star, mega star. That question. The question will be define contract of partnership and its essentials. Partnership is a relationship between two or more persons. How many persons? Who have agreed to share the profits of the business, profits of the shared owned by all, any one of them acting for all. First of all, first essential is there must be minimum of the two or more persons to enter into contract of partnership. There must be minimum of two partners. Yes or no, sir? The partner must be recognized by law. He must be recognized by law. The person can be a natural person, he can be an artificial person. But if a person is not recognized by law, he cannot become partner. For example, firm is not recognized by a partnership act. Firm is not a natural person, firm is not an artificial person, firm is not a person at all in the eyes of law. Partnership act never recognizes partnership as a person. So two partnership firms cannot enter into new partnership. However, partners in the firm can enter into partnership. Important. Minor cannot become a partner. Generally, minor can become a partner if it is an existing firm with the consent of all the partners and to share only benefits. And partnership act is silent regarding the maximum number of partners. So, maximum number of partners is specified by section 464 of the Companies Act. As per section 464 of the Companies Act, maximum number of partners can be 50. If number of partners exceeding 50, it must convert as a company. Next, there must be agreement. There must be partnership is a result of the agreement. No agreement, no partnership. No agreement. So there must be an agreement entered by all the partners, all the persons. So it is voluntary in nature. Which nature, beta? So if you want, you can enter into agreement. You can become a partner. Otherwise, not required. It is contractual in nature. No contract, no agreement, no partnership. It is voluntary. It is not compulsory in nature. This agreement can be expressed or implied. If it is expressed, it can be oral, it can be writing, However, in order to avoid disputes in the future, it is better to be in. So there must be association of the persons. There must be minimum of two or more persons. There must be business. So no business, no partnership. Association formed for charitable purpose is not a partnership. There must exist some kind of the business. Business includes every kind of trade, occupation, profession. Every kind of trade, occupation, and profession. Trading means buying and selling of the goods. Profession means services. So, if the motive of the business is acquisition of the gains, then it will become partnership. If there is no gaining from the business, it is not a partnership. So, there is no partnership where there is no intention to carry on the business, no intention to carry the business, no partnership. I kept start. We discussed enough examples also. है ना बेटा? Gopal, Satish, and Santosh entered into agreement to get the cloths to distribute to victims of the Tufan. So distribution is not a business. Distribution is not a charity, beta. Charitable purpose is not a business. And there must be agreement. There must be agreement to share the profits. Sharing of the profits is essential. Sharing of the profits is so there can be no partnership where only one partner taking the whole profits. Five partners are there. Only one partner is taking on the profits. It is not a partnership. It is not a. There must be sharing of the profits. So partners must agree to share the profits as per agreement. Agreement to share the losses is not essential. Sharing of the profits essential. Sharing of the profit loss is not essential. There are a few partners who take only profits but not the losses. Sharing of the profits essential. Sharing of the losses not essential. So it is open to one or more partners to take the all the losses. ABCD is there. ABC will take the profits and losses. D will take only profits but not the losses. Can it be? Yes, because D is a partner in profits only. Next, conclusive evidence of the partnership is the mutual agency carried on by all, any one of them acting for all. So all are doing for everyone or one is doing for everyone. Mutual agency. Mutual carried on by all, any one of them acting for all. This is the conclusive test of partnership. Sharing of the profits is only prima facie evidence, primary evidence. Which evidence? Sir? On the face evidence. Prima facie means on the face evidence. But this is conclusive. If sharing of the profits is there, no partnership may be there, may not be there. But इसको बोलते हैं mutual agency. If mutual agency is there, no, पक्का there is a partnership. Yes or no, sir? So business must be carried on by all, any one of them acting for all. This is the cardinal principle of the partnership. If it is there, it is a partnership. If it is not there, there may not be partnership. So it is said to be mutual agency. Each partner is making double action. Each partner is acting as agent cum principal. Agent cum. For example, three partners are there: SG, Rajni, and Sahiti and associate. Yes sir, no sir. If SG is selling the goods, I become the agent. They become the principal. If Rajni is selling the goods, Rajni will become the agent and others will become the principal. So previously I am the agent, now I am the principal. इसको बोलते हैं mutual agents. Which agency? So here mutual means one for another. One for I am your agent, you are my agent. You are my principal, I am your principal. Mutual agency. Each partner makes double action. Principal come agent. Any act of the partner will bind the all the partner. Even one partner is doing something, all other partners will be liable. Even Rajni is selling, whole firm will be liable. Even SG is selling, whole firm is liable to customer. Even Sahit is selling, whole firm is liable to customer. Each partner carrying on the business is the principal as well as agent. Every partner will act as agent come principal. So it may be noted that true test of partnership is mutual agency, but not sharing of the profits. But the true test of partnership, mutual agency, but not the sharing of the profits, but not the sharing of the profits must be there. It's secondary evidence. Primary evidence is the mutual agency. Then, then we discuss the true test of the partnership. The true test of the partnership is mutual agency. Actually, the three things are there. The true test of the partnership is decided by relationship existing between the partners. So, three things are essential to make the partnership. There must be agreement. There must be agreement. and there must be sharing of the profits, sharing of the, these two are the secondary evidence. The primary evidence is the carried on by all, any one of them acting for all. That is the mutual agency. So there must be an agreement. Partnership created only by agreement but not by status. Just because I'm taking by birth in the Gupta's family, I become Gupta. That is by status. So the three partners are there: A, B, C, D, Ajay, Bharat, Charan, Dhiran. Dhiran is getting a son. Can Dhiran become the partner? No, by status he cannot become a partner. That's why members of HUF carrying on the business is not the partner. He's not a. You become a member of HUF by birth, but not. It is HUF is not a partnership because a person will become the member of the family by birth. Partnership arises from the agreement. That's why member of HUF and Buddhist husband, Buddhist Burmese Buddhist husband and wife carrying on the family business are not the partners. And there must be sharing of the profits. Sharing of the profits does not make the person as a partner. Just because you are sharing the profits, you may not become partner. For example, beta, lender of the money. She's taking the profits but not the partner. So Sahiti and Rajni starting the business and giving the 10 lakhs. I'm giving 10 lakhs capital loan. I said, don't give me any interest, give me 20% of the profits. I'm a lender or partner. I'm taking the profits but not the partner. Employee, servant or agent. So Sahiti and business, Sahiti and Rajni doing the business and the employee and the employee. I don't mean fixed salary. Do one thing, give me 30% of the profits as my salary. And the employee sharing the profits but not the partner, but not the widow or children of the deceased partner. So ABCD are the partners. A mar gaya. Ajay mar gaya. Ajay share will be given to his wife or his son. Whether he is taking the profit, yes, but not the partner, but not the, because there is no agreement between the son of the Ajay and buyer of the goodwill, buyer, seller of the goodwill. So I have a brand in the Hyderabad, SG Classes. So these two people purchased my business, Sahiti and Rajni. They're running my brand name. I said, don't give me any fixed amount. For next 10 years, give me 20% of the profits. I'm taking the profits, but not the partner, but not the. So every person who shares the profits may not be partner because sharing the profits only prima facie evidence, but not conclusive evidence. Then, yes or no, sir. The last one is the business must be carried on by all, any one of them acting for all. Is said to be mutual agency. Which agency? Existence of the mutual agency is the cardinal principle of the partnership. So, if mutual agency is there, it is a partnership. Otherwise, it is not a partnership. Mutual agency means each partner is acting as principal come agent. I am your agent, you are my agent. If I am selling, I am agent, you are principal. If you are selling, you are agent, I am the principal. Double action. Which action? So if it's asking in the exam what is the true test of the partnership, you should write the these three headings. Better देखो VV IMP I kept. और yeah. So next one also very important. Shala means shala important. Cases where there is no existence of the partnership. There are few cases their partnership is not being to be there. There was a famous case now. So in this case now, Santi Ranjan Das Gupta. In this case now, it was held that there are few cases. In these cases, there is no partnership. For example, parties who do not maintain the record of terms and conditions. Partners are not maintaining the terms and conditions. So there is no oral agreement, there is no written agreement. It is not a partnership. It is not a. They don't maintain any terms and conditions. And partnership business has maintained no accounts of its own. They don't maintain books of accounts. Don't maintain terms of contract. That is, there is no partnership deed, there is no oral deed, there is no oral agreement, there is no written agreement, there is no books of accounts, and no account of partnerships opened in the bank. In the farm name, there is no bank account is opened. Books are not there, agreement is not there, no joint bank account, and no written intimation is given to Deputy General of Procurement. So never informed to government regarding their business, joint business. Which business? So it is not a partnership. So he will ask in the exam, explain the cases where there is no existence of the partnership in the exam, फटाफट 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 ये 4 पॉइंट लिखना। कैसे लिखना? आपको फटाफट 4 मार्क आता। कितना मार्क आता? नहीं लिख रहे 4 अटेम्प्ट लिखना पड़े बेटा। कितना अटेम्प्ट? I hope you will not get those many attempts. You will clear the first attempt itself. You will go to CA enter, you will clear CA enter also, then go to article ship. Is it? SMS. So, focus more on 6 months. How many months? 5 to 6 months is there, no? Focus like a laser. Next, partnership versus company. Partnership versus direct question exam में आता है बेटा, direct question. So, partnership is not a separate person. Partnership, partners both are one and the same. Individually they are called as partners, collectively called as the firm. But in case of company, company अलग होता है, member अलग होता है. Reliance is different, SG is different. Even I have the shares in Reliance, I am different, Reliance is different. For example, Rajini, Sahiti, SG and Gopal forming the partnership firm. We both are one and the same. We all are one and the same. Done. Super. So partnership does not enjoy separate legal existence. So there is no separate identity for partnership, but company has a separate legal existence. Is a company is a separate person in the eyes of law as per Companies Act. But partnership is not a partners liability unlimited because partnership and partner one and the same. In case of company, members liability limited to the extent of the unpaid value. Which value? I promise Reliance to give 10 rupees, I give 6 rupees. My liability is only 4 rupees. For liabilities of Reliance, I am not liable. For partnership liabilities, partner is liable because firm or partner one and the same. Partners are like wife and husband. Member and company is like lovers. They're different. आराम बेटा ये ऐसे बोलता था आपको समझ में आता। Partner and partnership firm both are same. If partner die, firm will die. Company is different, member is different. If you die, will I die? No. That is a person, it is a person. So partnership does not enjoy the long life. Does not enjoy death, sickness, insanity of the partner may affect the partnership existence. But company enjoys the perpetual existence. Member may come, member may go, member may die, but company will remain same because if you die, I will not die. Here, partners, minimum partners 2, maximum 100, but as per rule 10, it will be 50. In case of the company, minimum number of members 7, there is no maximum limit. And transfer of the interest. A partner cannot transfer his share to someone without the consent of all other partners. Rajni, SG and Sahiti are partners. I want to sell my share to Gopal. I can't sell unless these two partners are agreeing. But in case of company, 1 lakh shareholders are there. I want to sell my share. Will I ask all other shareholders? Just like that, I can sell. Agency. In case of partnership, there is a mutual agency among the partners. If you sell, I am liable. If I sell, you are liable. In case of company, 1 lakh members are there. If one member does, one member does something, other member will not be liable. Next, distributable profits. In case of partnership, profits must be distributed as per partnership deed. And in case of company, so it is not compulsory. Distribution of the profits is not compulsory in case of the company. Next, partnership is controlled by all the partners. Company is controlled by the board of directors. Property of the firm registered in the joint names of all partners because firm is not a person. To register the property you must be a person. The partnership form, no, the property registered in joint names of all the partners. In case of company, the property of the company registered in company name itself because company is a person. Company is in case of partnership. So Rajini, Sahiti, SG are the partners and we have to give the money to Gopal. Can Gopal file a case on me? Yes. Creditor of the firm is nothing but creditor of the partner because both are the same. Firm and partner are the same. But in case of the company, company has to give 10 lakh rupees to Rajini. She is my neighbor. So I'm the member of Tata Motors. Can you file a case on me? Tata has to give you money. I am different, Tata is different. Auditing is not compulsory. Auditing is mandatory in case of the company. Done. Next, Partnership versus club. Club is an association of the people with common objective without any motive to make the profit. So club is motive is not to make the profits, but promoting the mutual benefit. Which benefit? Like country club, Lions club, Rotary club, Secunderabad officers club, amma, mansion house, fashion club anta, fashion. I don't know that part. Ah, so partnership. Yeah, partnership is business oriented and making of the profits. But club is not aimed at making of the business, not aimed at making of the profits. In case of partnership, maximum number of partners can be 15 as per rule 10. And in case of club, there is no limit on the maximum number of members. And partnership does not enjoy the perpetual existence. If partner come, partner die, firm will be affected. But club is not like that. Members may come, members may go, members may die, but club will remain 10. Partnership. There is a mutual agency among the partners. If one partner does, other partner is liable. But here, if one member does something, other member is not liable. There is no mutual agency among the members of the club. Next one is the HUF versus partnership. HUF versus, so HUF means Hindu undivided family. It consists of the all male persons linearly descended from a common ancestor. Here only males are the part of the HUF. Females will become part of their family. My wife is member of my family, but my daughter is not part of my family. My daughter will marry. She will change her surname. She will go to her family. Her family means my daughter, her husband, her children. Are it includes unmarried daughters and wives also. My wife is my family. My unmarried daughter, my family. Once she's getting married, now she will go to her family. Then, so it contains three generations. Three generations and all. That is the son, grandson, greater grandson. They are said to be co-partners, members of the HDF. So they can enjoy the property owned by father, grandfather, greater grandfather. Property made by father, grandfather, greater grandfather. Last three generations can be enjoyed by son, grandson, greater grandson. Then the property owned by last three generations is said to be ancestral property. Which property? In India, HF is of two types, Dayabaga and the Mitakshara. In case of Dayabaga, it is applicable to West Bengal and Assam. A son will get the share in the property of the HF only after death of his father. But in case of Mitakshara, applicable to whole of India except West Bengal and Assam, a person can become the member by birth. By interest. Next, HF versus partnership. HF versus HF versus partnership. Partnership will arise from the agreement. No agreement, no partnership. HUF is arise from status. By status, by birth, you become the member of that family. Chaudhary family, Gupta family, Agarwal family, etc. etc. family. And it is governed by Partnership Act. It is governed by Hindu law. Here persons are known as partners. Here persons are known as co-partners. Minimum 2, maximum 15. Here there is no limit. ఎంతమంది అయినా కలవచ్చు ఆడు ఓపిక వన్స్ అపాన్ టైం సో మెనీ బట్ నవ్ ఇట్ ఇస్ నాట్ ఈవెన్ వన్ a new partner can be admitted with the consent of all other partners. Yes or no, sir? SG, Gopal, Rajini, Sahiti are the partners already. Satish want to enter. Can he enter? Yes, with the consent of all other partners. But in case of HGF, before taking the birth, we will not take the consent of all the family members. Can I take my birth in your family? Will we ask? Ala puttestam ante. Ela? Ala. Male person will become the member by birth. Next, minor cannot become a partner unless three conditions are satisfied. But here, minor also will become the member by birth. Here, female can become the full-fledged partner. Here, generally, female cannot become the member of the family by birth. So, she is a member of the family only until her marriage. The traditional concepts. Which concepts? Here, every partner has the authority. Every partner is equal. But in the HUF, everyone is not equal. Who is superior? Grandfather. Then father. Then you. So only Karta has the infinite authority. Karta means head of the family. Done. Next, partner's liability unlimited. Here, Karta's liability unlimited and other members' liability is limited to the extent of their share in the HAF property. So, in HAF, 10 males are there, property 1 crore. So, each male worth in 10 lakhs. So, liability of the each male member is only 10 lakhs. Next, every partner can ask for the books of accounts. Can you ask your father how much property you have? No, he will beat you. You can't ask. You can ask whatever you want, books, pens, etc. You can't ask how much property we have, how much I will get after your death. Can you ask? No, Maharaj. Next, effect of the death of the partner. If partner dies, firm will also dissolve. In case of HCF, members may come, members will go, members will die, but HCF will remain same. The family will remain same. Yes or no? Good girls, good boys. Next one is the co-ownership. A ownership. So Gopal is there. Who's Buddha? Gopal. Gopal is having two sons, Satish and Satya. Satish and Satya. Both the sons are curiously waiting for Papa's death. One find the Gopal mar gaya. Gopal mar gaya. After death of the Gopal, no beta, that the building is in Gopal building. So went to his sons. They become the joint owners. Joint co-owners. The both brothers Satya and Satish. Joint owner. A owner. So, partnership will arise from the agreement. Joint ownership may arise from agreement, may not arise from the agreement. Here, Satya and Satish will become the joint owners without any agreement. For example, Santosh and Ganesh purchasing the property jointly. They become joint owners by agreement. Co-owners by agreement. Here, partnership, there must be business. Here, there may be business or may not be business. Since business is there, sharing of the profits and losses will be there. Since there is no business, profits and losses may be there, may not be there. There is a mutual agency. There is no mutual agency among the co-owners. Here, persons are called as partners. Here, persons are called as the co-owners. Minimum 2, maximum 50. As per section 4, 462 100, but as per rule 10, 50. Rules will override the section. Here there is no limit. ఎంతమందిని co-owners ఉండొచ్చు. So a partner cannot transfer his share to stranger without the consent of all other partners. Co-owner can sell his share to anyone. Partner cannot demand for the his share of property when you're in the partnership form. But co-owner can ask for the partition of the property. Then we discussed the partnership deed. Which deed? First, what is the meaning of a deed? Then, what is the meaning of partnership deed? Let us try to understand. Clear? First of all, what is the meaning of the deed? Deed is the agreement in writing. Deed is a partnership deed is the agreement among the partners. It will contain the rights and duties of the partners. Rights and duties of it must be stamped as per Indian Stamps Act. It will contain the important terms of the partners. What partners should do, what you should do, what I should do. It should be clear and elaborative and unambiguous. There must be clarity in the partnership deed. Deed must not contain any provision contrary to partnership. It must be within the partnership act. It must not be unlawful. We have to give one copy to all the partners. It can be oral, it can be writing. In order to avoid the disputes in the future, it is better to be in writing. And it must be filed with the register of forms. Partnership deed is silent, no. Partnership act will be applicable. It can be altered with the consent of the all the partners. How many partners? This is an example of the partnership deed. I said, but I have stamped as per Indian Stamps Act. Contents of the partnership deed very, 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 very important. How much important? Super star. इसमें क्या रहता है बेटा? Name of the firm, address of the firm, business of the firm, name of the firm, address of the firm, business of the firm, date of commencement, duration of the partnership, capital contributions, drawing power, profit sharing ratio, interest on capital, salary to active partner, how to maintain books of accounts, who to operate bank account, how to make the investment. All these things will be there in the partnership paid. Done. So can we alter this? Yes, with the consent of the all the partners. After alteration of the partnership, it should be filed with the register of forms. Then types of partners, types of forms. Types of partners, types of forms. Forms are of two types. Particular partnership, partnership at will. At will means wish. At will means wish. Business forms are of two types. At will and particular partnership. First, and partners are of nine types. Active, nominal, sub-partner, outgoing partner, sleeping partner, profits only, incoming partner, partner by holding out, and minor, which is parent and minor. First of all, what is a partnership? At will. Will means wish. Will means it is a partnership where there is no duration of the partnership. So, Sahitya Rajini is she entering into a partnership agreement to do the business. But after how many days? 6 months or 1 year? Not specified. इसको बोलते हैं partnership will. At a will. Since duration is not specified, no, it can be dissolved by any partner anytime. Any partner by giving a notice and writing to all other partners. So it is a partnership where duration is not fixed. It can be resolved by any partner at any time by giving notice and writing to all other partners. But once notice is given, it cannot be withdrawn unless it is agreed by all the partners. We can dissolve the partnership from tomorrow, but not from yesterday. Only prospective effective, but not retrospective effective. If notice contains a date, from that date it will be dissolved. If notice does not contain any data, it is dissolved from date of communication. Particular partnership. It is a partnership from which is formed for particular purpose, particular venture, particular period, 3 months, 6 months. If partnership is formed for the 6 months, particular partnership. Can it continue beyond 6 months? Yes. If it is continuing beyond 6 months, it will become partnership at a will, which can be dissolved by any partner anytime. Partnership is formed for 6 months. Can I close it before 6 months? Yes, with the consent of all the partners. With the consent of done. Generally, it comes to an end on completion of the 6 months. Done na? So if it is comes to an end on completion, if it is continuous, it will become partnership at will. It can also be closed before the expiry of the 6 months with the consent of the all the partners. Next one is the types of partners. Yeah, types of partners. First one, active partner. Which partner beta? He is also to be ostensible partner who take active part in the day-to-day activities of the firm. He buy, he sell, he will do marketing. Active partners. So he is liable to third parties because of him only customers are coming. He is liable to third parties for activities of the firm. If he is leaving, retiring from the partnership firm, he must give public notice because everyone is coming because of his face only. And something happens to him, his incapacity may affect the existence of the firm. Something happens to him, no, shop will be affected. Next, sleeping partner, a doormat partner. Which partner? Doormat. Who does not take active part. He will do the capital, but he will not come to shop regularly. Will he liable third parties? Yes, because he become the principal. Other partners become agent. So he need not give public notice of his retirement because no one knows that he is a partner, and his incapacity is not the reason for the dissolution of the firm because we're not taking his services much. Something happens to him, nothing will happen to shop. Nominal partner, he gives only name and fame. He will not give the capital, he will not take the profits. We will take only his name, fame, brand name. He is liable to other parties because of him only customers are coming, and he must give public notice of his retirement because of him only public is coming to shop. And his incapacity may not be reason for dissolution because we need only his name, fame, but not his day-to-day activities. Partner in the profits only, he is nothing but the active partner except losses. So he takes only profits but not the losses. Is liable to third parties. He must give public notice, and his incapacity may not be reason for dissolution of the firm. Firm will not be affected. Last one, sub partner, partners. There are four partners: are the Ajay, Bharat, Charan, Dhiran. They want to form the business. Everybody has to contribute 10 lakhs. How many lakhs? But these three people are having 10 lakhs. He's having only 2 lakhs. Then he went to Ganesh. He's taking 8 lakhs rupees from the Ganesh. And Ganesh 8 lakhs, his 2 lakhs is keeping in the business. Who are the partners? A, B, C, D. and G is the sub-partner of the Ajay. Yes, sir, no, sir. So sub-partner is a third party to partnership firm. Who is a third party? He is stranger and is not liable to third for customers of the firm because he is no more partner. And there is no question of the retirement because he is not a partner at all and his incapacity will not affect the business. And next one is the minor as a partner, star star, superstar. Star star, very very important from exam point of view. मित्रों मेरे प्यारे देशवासियों, minor as a partner, minor as a so generally minor cannot become a partner in the partnership firm. Minor can become a partner if it is an existing firm with the consent of all the partners. He will take only profits but not the losses. If these three conditions are satisfied, A plus B plus C, he may become partner. Before attaining majority, he has the right to share the profits, right to examine books of accounts only, but not other agreements. Because he's a minor, a bacha, he can make the rocket with the agreements. Only books of accounts he can examine. Liability. So his liability is maximum to the extent of his share of profits. He will not be personally liable. Even firm is becoming insolvent, he will not become insolvent because his liability is limited. Minor cannot be declared as insolvent. Next, after attaining majority, he joined in the year. For example, he joined in the year 1 1 20 20 as a minor partner. Which partner? And he become major on 1/1/2026. He become major. He has two options, whether to continue or retire. So within 6 months from attaining majority, within 6 months from getting a knowledge that he was part of the partnership, within 6 months, whichever is later, he must give public notice whether to continue or not. If public notice is not given, he is continuing as a partner. Deemed to be continuing as a partner. And I kept a star also here. Question में रहता. He is not giving any public notice. If he is continuing as a partner, he will be liable. He has right to share the profits like any other partner, and he will be liable from the date of admission. From the date of admission, from 2020, he will be liable because from 2020 he is enjoying the benefits. That's the logic. If he is retiring, so he has right to take the share of profits, and share of the profit. And he has right to get the interest until his accounts are settled. He is retiring on 1/1/26, but his accounts are settled on 26/6/26. For the 6 months, he is eligible to get the interest. Next, if he is retiring as a partner, liability, he will be liable until public notice is given. So when he is retiring 1/1/26, but when notice is given 6/6/26, till this time he is able to be acting as a partner. He will be liable for the activities of the firm during this period. But after giving public notice, he will not be liable for the activities of the firm. Then next, partner by holding out, or partner by estoppel. Actually, he is not a partner of the firm, but if representing him as a partner, he should stop it. If he is not starting, he will become partner by estoppel. So there are three partners: are ABC and associate. Ajay, Bharat, Charan. Dhiren is their friend but not the partner. He is not a partner. One fine day, ABC said to me, Srinath sir, Dhiren also partner. Before him only. He remained silent. Dhiren remained. He should stop that. He should say, ABC, Ajay, Bharat, Charan, my name is Dhiren. I am not your partner. I am your friend. Just friend. He should stop that. He is not stopping. He become partner by estoppel. By believing the Dhiren, I gave the role to ABC and associates. Whether Dhiren is liable to me? Yes. Otherwise, ABCD and associates are the partners from so many years. For last 10 years, they are the partners. One fine day, A is retiring. He retired on 1/1/26. 1/1, he retired. He gave public notice on the 6/6/26. Until public notice is given, he is deemed to be partner by holding or partner by. But public notice is not required in two cases. One is the death, other one is the insolvency. Because if a person dies, everyone will discuss about him. Obviously, if a partner become insolvent, people love that because others are suffering. Everyone will discuss about that. Legal notice is not required. With this, we have done with the revision of part 1 of the partnership. Done. Have a great time. Enjoy the day. Prepare well. SG signing off. Take care. So Welcome back, sir. Let us revise the rights, duties, and authority of a partner. Important chapter in partnership. Here we will discuss three things. One is rights of a partner, other one is the duties of a partner, and the authority of a partner. Authority of the first, let us start with the duties of a partner. Duties of a partner are two types: mandated duties, general duties. Mandated duties means which cannot be altered by mutual consent. Cannot be altered by mutual consent. You have to follow as it is. General duties which can be altered by partners with a mutual consent. This can be altered. This cannot be altered by mutual consent. First duty: carry on the business for the greatest common advantage of all the partners. We should not do the partnership for the benefit of one of the partner. We must do the partnership for the benefit of common benefit of all. Common benefit of, but not for single partner. Yes or no, sir? And every partner must be just and faithful to each other. Faithful means namakam, bharosa. So every partner has to believe the other partner, then only relationship will sustain. We can't change that. Every day I will doubt you. That is not a partnership. So to render the true accounts, every partner has to show the true accounts to other partners, especially to sleeping partner, to indemnify the firm from the loss because of the partner's negligence. If there is any loss to firm because of the fraudulent activity of the partner has to compensate the firm. Compensate them. I kept a star. This came in the exam so many times. So if firm is getting a loss due to fraud of the partner, due to, we have to compensate the firm. We discussed one example also, taking the sweets every day from the shop, selling outside. What he's doing? Fraud on the firm. So who's getting a loss? Firm due to fraudulent activity of the partner. So we have to compensate. Next one is the general duties which can be altered by mutual consent of the partners. First one, to be diligent, to attend the duties diligent, that is carefully. Every partner has to attend the duties diligently, carefully, not to claim remuneration. No partner is eligible to get the remuneration unless agreement provides. Partners can take the profits, but not the salary. Yes or no, sir? So this can be altered with a mutual consent. Partner is eligible to get the salary if agreement provides, otherwise not eligible. And to contribute equally to losses. Every partner has to contribute equally to losses. It can be altered. I will take only profits but not the losses. Can we alter? Yes. And to indemnify the firm for the negligence. This is for negligence and this is for the fraud. Fraud is intentional, negligence is unintentional. That's why it is mandatory, it is optional. And to use the farm property for the business of the firm. Generally, we have to use the farm property for the business of the firm, but not for the personal purpose. We can alter this. We discussed yesterday example also. That is, we can use up to 50 kilometers per day, per month for personal purpose, farm car. And account for and pay the personal profits from the transactions. Very, very important beta. If partner is doing any personal profits from the business of the firm, you have to give it back to the firm. Then we discuss one example, sugar example. So we purchase, firm is there selling the sugar, partner also producing the sugar, selling the sugar to firm for higher price. Which price? So what the higher price the firm is paid to this partner. So you have to refund all the money to firm. That question is very, very important also. And to account for and pay the personal profits from the competing business. Yes, partner can do the, partner should not do the competing business when you're a partner, when you're acting as a partner. If you're doing any competing business, getting any personal profits, surrender it to the firm. These are the mandate. This can be duties which can be altered, which cannot be altered. Mandatory duties cannot be altered. General duties can be altered. Next, rights of the partner. First one, right to take the part in the business. Every partner has a right to conduct the business. Second one, right to express the opinion. It is two types. Majority of the opinions will be decided by the majority consent. A consent, all the proposals will be decided by the majority consent. All the proposals decided by the majority consent. And to change the business, to change the business of the firm, we require the unanimous consent of the all the partners. Yes or no, sir? Then every partner has right to access to books of accounts. Every partner has to share the profits equally. Every partner is entitled to get the interest on the capital only out of profit, only out of profits if its agreement provides. And right to get interest on advance. If any partner is giving a loan to firm, giving the loan to firm, that partner is eligible to get the interest at the rate of the 6% even in case of losses because it's a loan. Next, right to be indemnified for the liabilities incurred by firm in case of emergency. If partner is incurring any expenditure on behalf of the firm in emergency to save the firm, so that partner is entitled to be indemnified. we have to repay the money to such partner because he's spending the money on behalf of the firm. To prevent the introduction of the new partner, a new partner can be admitted with the consent of the all the partners. Every partner can restrict the prevention of the introduction of the new partner and right to retire. In case of partnership petible, partner can retire with by giving a notice in writing to all other partners. If it is a particular partnership, partner can retire with the consent of the all the partners. And right not to be expelled. Every partner has a right to stay in the business. Partner cannot be expelled. Dakil dena. So said up. So partner can be expelled if it is agreed by the majority of the partners. It must be done in the good faith and it must be authorized by the partnership deed. Before expelling him, we have to give a reasonable opportunity of being heard to express his views. This is very, very important. But 10 stars. How many stars? 10 stars. And outgoing partner, which partner beta? Outgoing partner can carry on the competing business, but don't use the firm name, don't represent as a partner, don't solicit the customers of the firm, being an outgoing partner. And if partner is retiring until his accounts are settled, he is eligible to get the 6% interest. How much beta? Interest 6%. At the he has right to share the subsequent profits. Which profits? The till his accounts are settled. And every partner has a right to dissolve the firm if it's a partnership petible by giving a notice. If it's a particular partnership, with the consent of the all the partners, every partner has a right to close the partnership form. Done. Below, next concept will be authority of a partner. Yeah, beta? Authority. This one also very, very important, beta. I kept so many stars. How many stars? So many stars. Authority of a partner means right of a partner, capacity of a partner to bind the firm by his activity with the third party. So there one firm is Ajay, Bharat, Charan, Dhiran and associates. Ajay, Bharat, Charan, Dhiran. So who's selling the goods? Ajay. To whom? Ishwar. Even Ajay is selling. Whole firm is liable to Ishwar. It is said to be authority. It means power of a partner to bind the whole firm by his activity with a third party. It is of two types, implicit authority and express authority. If authority is given to partner by the act, partnership act, implicit authority. If authority is given to partner by partnership deed, it is said to be express authority. And authority is said to be implicit authority if related to normal course of business of the firm and it is done in the usual course of doing the business and it is done in the firm name. Whose name? So, which activities will comes under implicit authority? Very easy, beta. To purchase the goods, regular goods, to sell the goods, and purchasing, settling the payment to suppliers. When you're selling, taking the money from the customers, appointing the servants, appointing the lawyer, borrowing the money. If you're borrowing, pledging the goods, and issuing the negotiable instruments. These 9 will comes under the authority. Even one partner is doing, the whole firm is liable to customer. Few things are there, but partner cannot do without the consent of other partners. Beyond the authority, restrictions on activities outside the scope of the authority. Statutory restrictions imposed by agreement. In the agreement, we cannot do anything. So, act is statutory means act. As per act, partner cannot do these activities without the consent of other partner. First one, to acquire the immovable property, you can't buy the property without the consent of other partners. And to sell immovable property without the consent of other partners, you can sell the building. And to submit a dispute to arbitration, that is the middleman to settle the dispute. To open the bank account in partner's own name, it must be in the firm name, but not in the partner's joint name, but in the firm own name. To compromise the claim, that is taken the lesser amount. Yes sir, no sir. And to relinquish the claim, here we will take 70% only from the customer. Here we will not take anything. 100% waiver. And to withdraw the suit filed by the firm, a partner cannot withdraw the suit filed by the firm without the consent of other partners. And to accepting extra liability. So to perform all these activities, partner should have the express authority by partnership deed. Which deed? Next concept of partners authority in emergency. Partners authority in emergency. Few cases, even partner has no authority. Partner is not having the authority. Doing something, still it will be liable, valid. So we discuss one example. One firm is beta ABCD and associates, Ajay, Bharat, Charan and associates. Clear beta. As per partnership agreement, partner should not they sit in the cloth. As per the agreement, partner should not go to the warehouse to bring the stock. Without the consent of other partners, will go together. and without the consent of other partners, we should not give the discount. There was a fire accident in the shop one fine day. Without the consent of the other partners, I was spending the money, saving the property, going into the warehouse, bringing the stock out, and then giving the discount to customer to sell the stock, affected stock. Whether can I give the discount generally? No, but here I am giving a discount. Valid and invalid? Because I am doing this, I am doing unauthorized activity. Why this? I am doing this unauthorized activity for the purpose of protecting the firm from the loss. As a prudent person, genuine person, as if his own case. I become the agent. I become the agent. Even it is an unauthorized activity, still it will be valid and firm will be liable. Then that question also important. Last concept, very very important from exam point of view. There is an implied authority and third parties. Everything also sometimes is asking the date question also. So first one, effect of restriction on the authority. So we're restricting the authority of a partner. He can't buy the goods, he can't sell the goods without the consent of other partners. Generally, partner has a right to buy the goods, right to sell the goods, but we are restricting his authority. Third party know, third party know about the restriction, then firm is not liable. Firm is not done. Third party don't know about the restriction, then firm will be liable to third party. Then effect of admission by partner. If an active partner is accepting liability, it is not an incoming partner admitting the liability by active partner. So when firm is about ABCD and associates, they are into sweets business. Which business? So SG, I am supplying the sweets. Who? What I am supplying? Sweets. So A is the active partner. She accepted the sweets. Accepted the sweets and bill also. So bill is 10,000. Who is supposed to pay the money? Only A, whole firm. So admission of the liability by partner is equal to admission of liability by the firm. Even one partner is accepting, whole firm will be liable. If the liability is accepted by the active partner, the liability related to activities of the firm. The liability must related to ordinary course of business of the firm. Even one partner is accepting, whole firm will be liable. Effect of notice to active partner. If this firm is not giving me 10,000 rupees, I give a legal notice to A. Legal notice to A. That is active partner. Legal notice to active partner is equal to legal notice to firm itself. So notice to partner is equal to notice to firm. If the notice related to activities of the business of the firm, notice is given to working partner, and there must not be any fraud committed by that active partner and third party against the firm. Next one is the liability of the partners. Contractual liability of the partners is governed by the mutual agency. If I am selling, I am agent, you are the principal. If you are selling, you are agent, I am the principal. Next, liability of the firm for wrongful activities. Still, if partner does any wrongful activity which is related to ordinary course of business of the firm, then firm will be liable. If partner does any wrongful activity which is not related to ordinary course of business of the firm, then firm will not be liable. In the kirana shop, we sell in the kirana item which is defective, firm will be liable. In kirana shop, we sell in the liquor, the firm will not be liable for that unauthorized activity. Then last one, liability of the firm for misappropriation by partner. ये भी exam में 2 बार है बेटा. Here, customer is giving the money to the partner, giving the money to one of the firm, one of the partner misapplied it. Firm will be discharged. So partner, third party will be discharged. Firm will be liable. And we give the money to whole firm itself. All the partners together, we are giving the money. One of the partner misapplied it. Still, firm will be liable, and third party will be discharged. We discussed enough examples also. Yes sir, no sir. Remember those examples. Property of the firm. Last one is the property. Not that much important. This goodwill he asked 1 to 2 times. What is the meaning of goodwill? एक दो बार आया बेटा. So property of the firm. How to decide whether it is a firm property or personal property? Decided by the agreement. Decided by the agreement will specify what is firm property, what is partner's personal property. If agreement is not there, we will decide based on the source. So if it is purchased with firm money, firm property. Personal money, personal property. Purpose, using for the firm purpose, firm property. Using for personal purpose, personal property. So property of the firm will include 3 things. That is, all the properties brought to common stock by the partners at the time of creation of the partnership firm. As my share bringing the furniture, as your share bringing the lights, as your share you are bringing the fans and ACs. So now it is all this will become the property of the firm, and property purchased with money belongs to money. With firm money we are purchasing a car. Whose car is that? Firm car. and goodwill of the firm. Goodwill is the name and firm enjoyed by the business. Yes or no, sir? So, goodwill is not defined under the partnership act. It is a reputation enjoyed by the partnership firm, which will helping to get the super profits. Which profits? Next, it can be sold. Goodwill can be sold. How to use the firm property? Property of the firm should be used exclusively for the business of the firm, but not for personal purpose. Exception. With the consent of the partners, we can also use the firm property for the personal purpose. As per agreement. As per we discussed, we can use a farm car for 50 kilometers per month per partner, personal purpose. And just because private property used in the business, my personal car I'm bringing into car, my personal laptop I'm bringing into shop, it will not become the farm property just because it is used in the farm. Done. With this, we have done with rapid revision of the rights, duties, and authority. Done. So remaining part we'll discuss in the next class. Have a great time. Enjoy the day. Prepare well. SG signing off. Take care. We'll do the scanner in the next class. Yeah. Welcome to the world of law. Next topic, registration of the firm. Only two sections, beta. What is the meaning of registration of the firm? Registration of the firm means getting the firm registered with the ROF. Registered with the of the area where firm supposed to be registered. For example, beta, in India, for every state we are having the one ROF. For example, company want to firm planning to register in the Hyderabad. We have to go to Hyderabad ROF. We have to file the documents with the ROF, and we have to obtain the certificate of registration from the ROF of the Hyderabad. ROF of the because we want to register in the Hyderabad. So, what is the meaning of registration? Getting the partnership registered with the ROF. That is register of the forms of the place where business is situated or proposed to be situated. What is the procedure, sir? This was asked once in the exam beta procedure. First, we have to obtain the application form from the ROF. Fill the we have to obtain the application form, and we have to fill particulars: name of the firm, address of the firm, business of the firm, name of the partners, address of the partners, and it must be verified by all the partners. It must be signed by all the partners. Take the details: name, address, spelling mistakes, name, male, female, age, etc. Fill this application form with the ROF. Then ROF will issue certificate of registration. This is a procedure for registration of the firm. So registration compulsory or optional? Registration is not compulsory. Registration is optional. Since it is optional, it can be registered at any time. It can be registered at the time of formation itself or later at any point of time. After registration, if any changes are there, change in the name of the firm, business of the firm, address of the firm, the same thing you should be filed with the ROF. Should be filed with the ROF. Changes are subsequently. So when the registration becomes effective, application is filed, filled signed application filed with ROF on 1127. But ROF entering these details in the books, ROF books on the 10/1/27. The firm is deemed registered from the first, but not from the 10th, because entering these particulars in the books is a clerical activity. Which activity? No brain is required because everything is examined and they have taken the application form. Next one is very, very important. 10 stars. How many stars, beta? Effects of non-registration of the firm. If firm is not registered, no. Firm cannot sue partner. Partner cannot sue the firm. Partner cannot sue the another partner. Firm cannot sue the third party. And third part firm, they cannot set off. Firm cannot set off amount exceeding 100 rupees. Up to 100 they can set off if it is not registered. Once again, firm cannot sue partner. Partner cannot sue firm. Partner cannot sue another partner. Firm cannot sue third party. Firm cannot set off amount exceeding 100. And rights are not affected by non-registration. Even firm is not registered, few rights will not be affected. Like the firm is not registered, still third party can sue the firm. Even firm is not registered, partner can sue for dissolution of the firm, accounts of the dissolved firm, share in the dissolved firm. Even the firm is not registered, official receiver of the insolvent partner can sue for dissolution of the firm, accounts of the dissolved firm, and insolvent partners share in the dissolved form. Even firm is not registered. Last one, even the firm is not registered, even the firm is not registered, firm can set off. Firm can up to 100. Up to, even firm is not registered, third party can sue the firm. And partner can sue dissolution of the firm, accounts of dissolved firm, share in the dissolved firm. And official receiver of the insolvent partner can sue for dissolution of the firm, accounts of the dissolved firm because to ascertain his share, and insolvent partners share in the dissolved form. And firm can set off up to 100 rupees. Then, so with this, we have done with the revision of the registration of the firm. Remaining part, the scanner, we'll discuss in the next class. Have a great time. Enjoy the day. Prepare well. SG standing off. Welcome back. Welcome back to the world of SG. Welcome back to the world of law. We'll revise topic 4 in partnership resolution. क्या है बेटा? फटाफट रिवीजन करेंगे बेटा. रैपिड डिस्कशन कैसे करेंगे? Resolution means discontinuation. Resolution means resolution of two types: resolution of partnership, resolution of the firm. Resolution of partnership also known as the recreation of the partnership, reconstitution of the partnership. Resolution of partnership. Other one is the resolution of firm. Resolution of partnership means old partnership comes into existence, closed. In such a place, new partnership comes into existence. Resolution of the firm means old partnership comes to an end, no new partnership comes into existence. The main difference: old shop will close, new shop will come between new partners. Resolution of partnership, recreation of the firm. Firm was created between ABC, created, constituted. Now D coming, ABCD understood set, recreated. Old form between ABC closed to new form between ABC recreated. A retired, A mar gaya. So between BCD new form recreated. Resolution of partnership or recreation of the form and reconstitution of the form. Resolution of the form means old form between A, B, C, Ajay, Bharat, Cheran comes to an end. No new partnership comes into existence. You can plan. Resolution of partnership may happen in 6 ways: induction of a partner, retirement of a partner, expulsion of a partner, insolvency of a partner, death of a partner, transfer of rights of the transferring, rights of the transferring. So out of these, first one is less important, less important, less important, less important, very important, very important. Then next, resolution of the firm. Resolution of the firm means old partnership comes to an end. No new partnership comes into existence. It is two types: without order of court of law, with the order of court of law. Star, superstar, star, mega star. That question will come in the exam. Without the order of court of law, with the order of court of law, without the order of court of law, with the order of court of law, without the order of court of law, it is again 4 types: by agreement, by compulsory, certain contingencies, and by notice. And resolution with the order of court of law, again 7 types: government action, then insanity of active partner, incapacity of the active partner, disconnect of any partner, persistent breach of agreement by any partner, transfer of interest, perpetual losses, any other distant equitable jobs. This is summary of the whole chapter. First of all, clean it up. If we explain on headings, chapter will complete. Delineation of partnership versus delineation of the firm. Delineation of the partnership means old relation will come to the relationship between the partners will change. Delineation of the partnership means relationship will change, but some will be there. Firm will be there. Delineation of the firm means relations will end. No new partnership comes into existence. There may or may not be changes in the partners. Partners will cease. Cease means no more partner from tomorrow. And business will be continued between new partners. Business will not be continued because there is no partners from tomorrow. And assets will be re-evaluated. We will make the re-evaluation account. Accounts will be realized. We will create the re-evaluation account. We will sell all the assets. Realizing means selling. Evaluating means historical cost minus depreciation, current value. Here, results into recreation of the firm, winding up of the firm. Old partnership comes to an end, new partnership comes into existence. Old partnership comes to an end, now new partnership comes into existence. Different between the resolution of partnership with the firm. I kept 3 stars are the question in the exam. Next, the constitution of the firm and dissolution of the partnership. Dissolution of partnership. Dissolution of the partnership. Dissolution of partnership will happen 6 ways. How many ways, beta? That is introduction of a partner, retirement of a partner, expulsion, insolvency, death, and rights of the transfer. First one, introduction of a partner. A partner can be admitted to existing firm with the consent of other partners. Consent of the so there is a partnership called ABC and Associates. It was created in 2020. On 2026, 1 1 2026, he is admitted. ABCD and Associates. New partner is admitted. A new partner can be admitted to partnership with the consent of other partners. With the consent of or as per the existing agreement. We discussed examples. Once a partner's son become major, he will become the partner as per agreement. So, for example, he is admitted on 1/1/26. Before admission, he rights and duties. After admission, rights and duties. Rights and duties, rights and duties. Before admission, he has no rights. Because he is no more partner, he has no rights. Before admission, he has no right. He is not liable. He will not be liable for activities of the firm. However, he will be liable for activities of the firm in following exceptional cases. Three-party agreement is entered between old firm, new firm, and incoming partner. Which partner? Incoming partner is not liable for activities of the firm done before his admission. Generally, is not liable, but he will be liable in the following cases. Incoming partner will be liable for activities of the firm before his admission. New firm assumes the liabilities of the old firm. What's new firm? ABC. What's the old firm? ABC. Ajay Bharat Charan Dhiran. Previously, Ajay Bharat Charan only. And creditors acts the new form as the return. And is what is there? One question is there in the exam. In that question, so there is a old form ABC. They're supposed to give me lakhs. How many lakhs? 50 lakhs. Then new form came ABCD. He agreed to contribute along with ABC. Yes or no, sir? Fair enough. So how many people are liable to be ABC or ABCD? ABC only because my consent is not there. Yes or no, sir? Tripartite agreement. Just because partners are agreed, that will not be sufficient. They will be liable if and only if creditor also accepted. If my consent is not obtained, they will not be liable. They will not be. This question came because it is between and is the what is the better? And minor after becoming major, he will be liable for activities of the firm from the date of admission. That is for activities of the firm. Even he was not a full-fledged partner, for that activity service, he will be liable if you want to continue as a partner. Right? So then came on 1/26. After his admission, rights and duties. Rights. Right to share the profits and losses along with other partners. Right to share the profits and losses along with other partners as per his profit sharing ratio. Liabilities. He will be liable for activities of the firm after his admission. Then next one is the we can keep 1 star. 1 star. Keep. Second one is the retirement of a partner. 2 stars I keep 2 to 3 stars. Retirement. Oh, a partner may retire. If it is a partnership at will by giving a notice. By giving a notice. If it is a particular partnership form with the consent of all the partners. Or as per the agreement. As per agreement. We discussed example yesterday. Partner बुढ़ा हो गया तो जाना पड़ेगा. Once partner attends second, तो जाना पड़ेगा. He will retire. And partnership particular by giving a notice. Particular partnership with the consent of all partners. Or as per agreement. In these 3 ways, partner may retire. Partner may. For example, there is a partnership form with ABCD and Associates. ABCD and Associates in 2020 is created. In 2027, he is retiring. Firm will become ABC owned because he is retiring. So before retirement, partner rights and duties. After retirement, partner rights and duties. So before retirement, he has the right to share the profits and losses along with other partners as per the his share. Profit sharing ratio. Profit sharing ratio. Yes or no, sir? Liabilities. Liabilities of the partner. Liabilities of the partner before retirement. He will be liable. He will be liable for activities of the partnership firm before his retirement. So retiring partner continues to be liable to third parties until is determined. He will be liable for all transactions begun but not finished. For unfinished transactions also he will be liable. This retiring partner remains liable for all the acts done till the date of his retirement, but he will not be liable in exceptional case. Previously, ABCD agreed to give me 50 lakhs. SG. How many lakhs beta? 50 lakhs. Now, ABC agreed to settle me. Said, sir, we only will give you 50 lakhs, don't ask D. I also agreed for that. Then D will not be liable for the activities of the firm done before his retirement also. But my acceptance is mandatory. In the question, he will not give greater acceptance. Then greater acceptance is mandatory. So he will be discharged from by the same but tripartite agreement. Three parties will be the old firm, new firm, creditor between him, third party, and the new partners. Next, after retirement, his rights and duties. After retirement, D rights and duties. Here, this one is very, 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 very important. Rights. So after retirement, right now ABCD are doing the fans business. Which business better? Fans. So after retirement, he can do competing business. He can do of the old firm, but he should not use the firm name, should not represent as a partner, should not solicit the customers of the old firm. For example, D is dated in the month of January 27. His accounts are settled in the month of May. When he is dated beta Jan. When his accounts are settled May. 6 months we are using his capital. So we are paying his share of profits and capital in the month of May. 6 months we are using. Since we are using his capital, we have to pay share of profits, previous share of profits, that is 20%, for example, and 6% interest till his accounts are finally settled. And liabilities. So after retirement, will he liable for activities of the company? After retirement, whether he is liable for activities of the firm? Yes, till public notice is given. He is retired on 1/1/27. Public notice is given on 3/3/27. During this period, he will become partner by holding out. Partner by he will be liable for activities of the firm even after retirement till public notice is given. This is all about the retirement of a partner. Retirement of a partner, very, very important. Stars are there, stars are there. Then we'll do the scanner. In the scanner, I will show you all these things. Expulsion. Very, 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 very important. We have discussed so many questions on the expulsion in the second chapter, rights and duties of the partner. A partner can be expelled from the partners from Dakel Dena, Tosedam. So we can expel a partner if it is express power is there in the partnership deed, agreed by majority partners in good faith. We have to give the reasonable opportunity to that partner before expelling, and we should give a notice to that partner why we are expelling. Then before expulsion, rights and duties are similar to retired partner. After expulsion, rights and duties are similar to retired partner. Retirement, expulsion, both are same. Retirement means voluntary. Expel means forcefully we are removing because of his unlawful activities. Next, insolvency of a partner. Insolvency, death, both are same. Insolvency, death, both are same, and retirement, expulsion, both are same. So, if a partner becomes insolvent, he ceases to be a partner from the date of the insolvency, and if firm will be dissolved, not partnership. Total firm will be dissolved if the deed is silent, and his estate is not liable for activities of the firm after insolvency, and public notice also not required. Same in case of death also, beta. Death हो मर जाता, here body will be there but no value because he is insolvent. No money, no value. Yes sir, no sir, in the society. So from the date of the death, he will be ceased to be a partner. Firm will be dissolved if the deed is silent, and his estate is not liable for activities of the firm. Even his legal representative is not liable for activities of the firm after his death. Public notice also not required. Important. In the question, he will go. Public notice is not given. Is it required? Not required. Even if he is active partner. Next one, very, 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 very important. 10 stars. How many stars? Concept is easy, but he is asking. I don't know why. Rates of transfer of the partner share. For example, 4 partners are given A, B, C, D, and associates. A was in need of the money. D is selling his share to E, Ishwar. But ABC is not accepting E. ABC is not accepting E. Since ABC is not accepting E, no, he cannot become partner. It is transferee of the partner's share. A partner may transfer his interest in the firm by way of sale or mortgage or charge. Charge means security. Takatto, girvi. So during the continuation of the firm, E is entitled to receive the A share of profits. Previously, we used to give the profits to A. Now we will give it to E. But since E is not becoming partner because BCD also not accepting, E not entitled to participate in the business, not require books of accounts, not inspect the books of accounts. Of, at the time of dissolution, E can receive the transferors, receive the transferors as share of profits, share of assets, require the books of accounts to ascertain the transference share. Whose share? Next, continuing guarantee. Which guarantee? Continuing guarantee is a guarantee given for series of transactions from January to December. January to December. Yes sir, no sir. Who is giving the guarantee? ABCD and associates. ABCD and so unfortunately, on 1627, 1627, A or E introduced. Something is happened. There's recreation of the firm. From the date of recreation of the firm, continuing guarantee will be comes to an end for the future transactions because agreement will become void because the old firm is not there. Continuing guarantee is a guarantee which is given for series of whether you keep any stars there yesterday, 2 stars. Continuing guarantee is a guarantee which is given for series of transactions. It comes to an end from the date of the recreation of the firm. From the date of the when the firm is recreated on 1627, reconstituted. Yes or no, sir? Hmm? Next, dissolution of the firm. Dissolution of the firm. Dissolution of the firm is two types. Without order of court of law, with order of court of law, without order of court of law, 3 stars, with order of court of law, 7 stars. Without order of court of law, 4 types. With order of court of law, 7 types. First one, without order of court of law, without court involvement, we can close the firm. Old firm will close, no new firm will comes into existence. First one, by mutual agreement. Firm will created by mutual agreement. Firm can also be closed by mutual agreement. One find a 4 partners sitting together. अरे हमसे नहीं होता चलो let us close. चलो बंद करेंगे दुकान from tomorrow. Next one, compulsory dissolution. Better to enter into partnership, there must be minimum of 2 partners who must be competent to enter into contract. All partners become insolvent. No competent partner. Firm will be closed. All but one. Out of 4, 3 become insolvent. Only one partner is solvent. He is incompetent. That is not sufficient. The firm will be dissolved. However, if you are having 2 businesses, wines and milk business, wine business will become illegal, but milk business is still legal. Yes sir, no sir. If they're having 2 businesses, firm is having 2 businesses, wines and water, wines and milk, wines and books. So wine business become illegal later, but books are there, milk is there, water is there. है ना बेटा? Clear ना? It is legal only. Firm will not be dissolved. See, exam में आया. However, when more than one separate adventure is carried on by firm, illegality of the one shall not itself cause the dissolution of the firm. Done. Next, on happening of certain contingencies. Firm is created for 3 years. 3 years is expired, it will come to an end. Completion of a venture. Firm is created for construction of a building. Building is completed, firm will come to an end. Death of the partner or insolvency of the partner. Contingencies means conditions. Last one. By notice. By notice. If it is a partnership edible, it can be dissolved by any partner anytime by giving the notice to all other partners. Done. Next one. With the order of court of law, very, very important. First one, insanity of the active partner, but not the sleeping partner. Insanity means pitchy, pagal, crazy. Where active partner become insolvent, insane. So court may order dissolution on suit filed by the any other partner, next friend of the insane partner. On application made by the any other partner or next friend, a friend or next friend of the insane partner. So court will order. Temporary sickness is not a ground for dissolution of the partnership. Permanent incapacity of the active partner. If active partner become permanently incapable of performing his duties, court may order for dissolution of the firm on application made by any other partner other than the partner who is becoming incapable. So any other capable partners can approach court of law for dissolution of the firm. Next one is the misconduct. Misconduct. If partner making persistent breach of if partner making the misconduct with the other partners or with the customers, then any other partner may approach court of law for dissolution. We discussed a few examples. He's throwing the gulab jam. Yes sir, no sir. And he is beating the customers. He's sending the customers to another firm. And misconduct need not be related to business of the firm. We discussed 2 case laws also better. Partner was traveling by train without ticket. One partner is doing the adultery on the wife of another partner. Yes sir, no sir. So any other partner may approach court of law for dissolution of the firm. Next, persistent breach of the agreement. If partner is continuously making the breach of agreement, then other partners may approach court of law for dissolution of the firm and transfer of the interest. If one partner selling his share to another partner without the consent of other partners may approach court of law for dissolution of the firm. Persistent losses. So day by day losses are increasing. 2010, 1 lakh, 2021, 5 lakhs, 22, 10 lakhs, 23 to 15 lakhs. So day by day losses are increasing to the partnership firm. There is no profits. So court may order for the dissolution of the firm. Any other just and equitable grounds, that is etc. So following reason, for generally firm will court will order dissolution for these reasons. These are not covered for etc. reasons. Also court may order for dissolution, like deadlock in the management, partners are not talking to each other. For both deadlock. Loss of substratum, the main purpose becoming unlawful. Substratum means main purpose and continuing quarreling between the partners, refusal to meet the business obligations on time, lack of confidence among the partners, some of the reasons for dissolution of the firm. Next up, rights of partners on dissolution of the firm. First one, partners generally. If partner is spending any money on behalf of the firm. Yes or no, sir? So we discussed few examples yesterday. So partner was spending, paying the electricity bill on behalf of the firm. Firm has reimbursed him or not? Yes. Firm is not reimbursing. Then he can exercise a lien on the property of the partnership firm. So partner can, if partner is incurring any expenditure on behalf of the firm, he can retain the property of the firm until his account is settled because he's spending out of his own pocket. Next, right to claim premium for premature binding up. So actually, ABC is bringing 10 lakhs. ABC is bringing 10 lakhs 2 years back, but D is bringing 15 lakhs extra, 5 lakhs extra. Why is bringing 5 lakhs extra later? Because these people give a guarantee. And D, you want to come join with us, and firm will continue come second 5 years. How many years, sir? Next 5 years from day one, you can enjoy the fruits. That's why it's bringing the 5 lakhs extra premium. But after 3 years, when the firm is dissolved, after 3 years only, so we have to repay the 2 lakhs. Then, so if a partner is getting goodwill as a premium for the specific period, if the firm is dissolving before the agreed period, before the, then we have to return the premium to the D. But D is not entitled to get the premium if the firm is dissolved due to death of the partner, if the firm is dissolved due to such incoming partner D itself, and before joining only we said we will not return the premium. Then he is not entitled to get the premium. Express agreement is there due to misconduct of the incoming partner and death of the partner. In these three cases, we will not return the premium. And right of a partner in case of dissolution on account of the fraud. So there are four partners are there, ABCD and associates. Out of ABCD, ABC are the active partners, D is the sleeping partner. So these people are making the fraud on the day. Yesterday we discussed example. D's son realized that ABC are making the fraud on his father D. Then D filed a case on the E. So how much losses happened to D? 4 lakhs. Yesterday we discussed example. Yes sir, no sir. So aggrieved party can approach court of law for dissolution of the firm. Aggrieved party has the following rights. He can exercise the lien on the assets for that 4 lakhs and treated as the creditor, and he has right to be indemnified that 4 lakhs because we got repay to D because we made a fraud on the D for 4 lakhs. Last one, right to restrict from use of farm name and farm property. Firm is dissolved on 1/1/27. 1/1 his accounts are settled on 15/1/27. So for next 5 months, firm is not there, but accounts is not settled. Yes sir, no sir. Until accounts are settled, every partner has the right to restrict the other partners from using the farm property, farm name until accounts are finally settled. Then these are the rights of the partners on dissolution, duties of the partners on dissolution. First one star. Duties of the partners on dissolution. First one, continuing liability for acts of the partners done after dissolution. Still, firm is dissolved on 1/1/27. Notice is given on 3/3/27. In this period, even firm is not there, partners will become partners by holding out. Partners continues to be liable till public notice is given. Yes sir, no sir. But public notice is not required in case of death to insolvency and sleeping partner. In these three cases, public notice is not required. Continuing authority of a partner after dissolution. So firm is closed on 1/1/27. 1/1. But in the shop, furniture is there, stock is there. Who should sell all the things? Every partner. So Partners will be continued to be liable until winding up of the affairs to complete the unfinished transactions. Two transactions are unfinished. So we discussed example rise back 12 months. 6 months are this delivered. Next 6 months, who is liable? All the partners, even for it is not there. Yes, sir, no, sir. Next, settlement of accounts and sale of goodwill. So, settlement of accounts. When firm is closed, the firm is into losses. Firm is into sale. Profits available. Yesterday we discussed. Net profits are 1 lakh and capitals 2 lakhs, 2 lakhs, 2 lakhs. ABC 6 lakhs we have to pay. Yes, sir, no, sir. Total 7 lakhs. How many lakhs, beta? But assets available on the date of insolvency will be 4 lakhs only. How many lakhs, beta? 4 lakhs. Clear? Assets are liabilities. Liabilities are 10 lakhs. Liabilities are 10 lakhs. But available pay and account is 1 lakh. First we will use the 1 lakh to pay the liability. Then in the capital, how much is the beta? 6 lakhs. So we will pay that one also. So कितना बच गया? Since still we need 3 lakhs rupees. Who has to pay this 3 lakhs? A, B, C. 1 lakh, 1 lakh, 1 lakh. As per profit sharing ratio. Out of their own pocket. Out of their own pocket. Because on the date of dissolution, firm is into losses. Firm is into. So first we will pay the liabilities out of the P&L account, out of capitals. Lastly, partners are personally liable for remaining partners. Done. And application of assets. Application of the that means when firm is closed, the firm is into losses, the firm is into profits. The firm is into profits when we closing. See, first we will repay the outside liability, third party liability. Which liability, beta? Third party liability. So some third party gave us 1 lakh rupees as a loan. Then one of the partner is advance. One of the partner advance 2 lakhs he gave. Yes or no, sir? And when the shop is started, no, beta, ABC is bringing the 3 plus 3 plus 3 lakhs, 9 lakhs. Capital and the beta 3 lakhs, 3 lakhs, 3 lakhs, bringing at the time of dissolution, at the time of creation of the partnership form. 9 plus 1, 10, no, 10 plus 12. Actually, on the date of the dissolution, the available assets are 15 lakhs. How many lakhs, beta? From this 15 lakhs, first we will pay the outside liability, then we will repay the partners debt, partners advance, partners loan, third party loan, partners loan. We will repay the capitals. We will repay the कितना बच गया 3 lakhs. So who will take this 3 lakhs? ABC 1 lakh, 1 lakh, 1 lakh. Done. In profit sharing ratio, profit sharing ratio. Clear. Next, payment of the partners debts and firm debts. Payment of partner debts, partners personal debts. You can keep 1 star here. I think we kept 1 star already. So on the date of dissolution, firm is solvent. On the date of dissolution, firm is solvent, partner is insolvent. See, on the date of dissolution, firm is solvent, partner is insolvent. So partner assets 10, liabilities 18. So A has to give me 18 lakhs. First I will take 10 lakhs from him. How much bach gaya? 8 lakhs. I said I will take this 8 lakhs from the firm property. But firm said, hey Babu, wait. But firm said, Babu, wait. From my assets, let me pay my liabilities. 15 lakhs assets, 15 lakhs, 12 lakhs liabilities. Kitna bach gaya? 3 lakhs. Out of these 3, what is the A share of 1 lakh? I can take only 1 lakh. Firm will use his assets to pay his liabilities. कुछ बचे गए तो it will be used for paying the liabilities of the partner. First, firm will use its property to pay its liabilities. Remaining property will be used to pay the liabilities of the personal debts of the partner. Second one, firm is insolvent. Firm is insolvent. Partner is solvent. Firm is insolvent. Firm assets 12 lakhs, liabilities 15 lakhs. So from this 15 lakhs, we will take the 12 lakhs here. Kisna bach gaya extra 3 lakhs. Then I'm trying to take this 3 lakhs rupees from the A balance, A assets. A said, hey Babu, wait. From my assets, let me pay my liabilities. ऐसा no sir. कुछ बच गए तो you can take. Partner will use his assets first to pay his liabilities. First, use partner's personal property to pay partner's personal debts. Remaining money can be used to pay the liabilities of the firm. Third one, Garner versus Murray case law. In this case, it was decided partner is insolvent to firm also insolvent. Partner is insolvent to firm also insolvent. So here, firm assets 12 lakhs, liabilities 15 lakhs. Extra liability for the firm 3 lakhs. Out of that, A 1 lakh, B 1 lakh, C 1 lakh. But if you go to A, no, A assets 10, no, liabilities 12. So A is also insolvent. So this A is 1 lakh is there, no, beta? A is 1 lakh. Who should take this B and C in closing capital ratio? Which ratio, beta? Not opening capitals. On the date of dissolution, what is the closing capitals? In that ratio, solvent partners has to take the insolvent partner share. Done. The Garner versus Murray case law. Next one, sale of goodwill 1 star. Sale of goodwill. So we can sell the goodwill like any other asset. Goodwill also one of the asset of the partnership firm. So if I am selling my goodwill to, if I am buying the goodwill from Polarity Sweets. Yes or no, sir? So what I can do, I can use the firm name. I can solicit the customers of the firm. I can represent myself as a carrying on the business of the firm. Being a seller, what Polarity can do, he can do the competing business. He carry on the business of the seller, but he should not use the firm name. Don't solicit the customers of the firm. Don't represent as the owner of the firm. Being a seller is no more he is the owner of the brand name. Done with this, we done with revision of the Partnership Act completely. So remaining part we will discuss in the next class. Have a great time. Enjoy the day. Prepare well. SG signing off. Take care. In the next class we will be doing the scanner. क्या करेंगे? फटाफट आंसर देना बेटा कैसा